On the third day of their presentation, the lawyers of petitioners challenging the removal of the presidential age limit and other recent constitutional amendments centered their arguments on the legality of the action, the 29 million shillings given to MPs to consult voters, and the extension of the term of MPs and local government leaders from 5 to 7 years.
But the parties were strange.
Councils James Byamukama, Wandere Ogaro, Elias Lukwago and Malema Birizi, who represents himself, agreed that the restoration of the presidential term limits was welcome, but questioned the legality of the process. The lawyers also argued that it was unlawful for the 10th Parliament to amend 105(2) of the Constitution to reinstate term limits without consulting Ugandans, yet the article is entrenched and can only be amended through a referendum.
Consultation and participation are not necessarily the same. So in your submissions, what ought to have been done? Is it mere consultation or is it ensuring participation?
If consultation is meant to bind me as a representative, why is there a provision in the Constitution for referendum?
By consulting at all, you have done your first duty of referring to the electorate. The impression you come with from those consultations may be another matter.
They further told the 5 justices of the Constitutional Court sitting in Mbale that the clause on term limits was not included in the Constitutional Amendment Bill tabled by Igara West MP Rapheal Magyezi.
Parliament cannot proceed on a new clause if it is not relevant to the subject matter. The subject matter was set out by Honorable Magyezi in both the memorandum and the number type.
Councillor Lukwago also argued that Parliament illegally gave each MP 29 million shillings for consultation from the Consolidated Fund, yet Article 93 of the Constitution prohibits Parliament from entertaining a private member's bill that has a cost implication to the taxpayer.
That the purported decision of the Uganda government to make an illegal charge on the Consolidated Fund by paying Uganda shillings 29 million only to every member of Parliament was inconsistent with and in contravention of Article 93A, 1 and 2 of the Constitution.
Lukwago also stated that it was not only unconstitutional for MPs to extend their term by 2 years, but that it would also hurt the national purse because the MPs would earn salaries from an additional 2 years without the mandate of the people.
The Act in itself made it very clear that that extension applies to the existing term of power, meaning that it will be extended up to 2023. So from 2021 to 2023, these members of Parliament are going to be paid. They are going to draw emoluments from the Consolidated Fund.
No action whatsoever ought to have been taken by Parliament in respect of this bill. Not even the application for leave to introduce it, because that was a motion which is prohibited. Not even the leave itself, and not even any other step.
According to the petitioners, it was also wrong for Parliament to suggest that the 5-year term of office for the President would be aligned to the 7 years for MPs without the people deciding in a referendum.
It means we are going to have 2 general elections. The one of the President and the one for Parliament at different times. Therefore, the Electoral Commission will have to spend twice the time.
That in essence means that the moment you peg the presidential term limits on the lifespan of the existing Parliament, you have in effect extended the term of president without going through the referendum, which is unconstitutional. Or going by his argument, they are speculating that the referendum is a foregone conclusion.
The petitioners have almost finished handling most of the legal issues in this petition, and they are now remaining with the procedure and security matters, which they will handle after cross-examining the witnesses on Tuesday next week. Habad Zewa, NTV, Mbale.